At one point during this incident, Officer Pratt tells Officer Robbins that he doesn't care if they use the actual letter of the law in deciding not to charge Gabby. He also tells Officer Robbins that it makes sense to go full on domestic assault. When people talk about the letter of the law, they are talking about the actual words written, the literal interpretation of the words. This line of thinking lines up with what Officer Pratt explains later on, that one officer may see things differently than another officer, and Officer Pratt believed this incident didn't meet the elements of the assault code as it was written. Applicable interview responses. Officer Pratt, in a subsequent interview with Officer Pratt, I asked how he reached the conclusion that this incident was more accurately categorized as a mental emotional health break than a domestic assault. Officer Pratt said he applied his numerous years in law enforcement as well as his overall life experience when stating he believed to see signs of mental health issues from both Brian and Gabby. Officer Pratt said, I saw the dynamics of their relationship. If there were all these red flags that he was going to murder Gabby, I didn't see those. I saw the same red flags I see every time I get called to a relationship issue. They don't call us there because they're doing great and want the police to come over and see how great they're doing. They call us because something is devolved. Officer Pratt described seeing this as another unhealthy relationship. Officer Pratt said if it was not an assault, which I decided it wasn't, then what could I call it? It wasn't an assault. If it was an assault, she would have had to be arrested. But there's elements to the offense of assault, and you have to meet those. I asked Officer Pratt if he believed a domestic violence assault took place during this incident. Officer Pratt gave the example that one officer will handle a call different than another officer based on their training, experience, and their interpretation of the totality of the circumstances presented to them. Officer Pratt said, it's our duty to document and to support with reasoning, logic, and hopefully the law backing us because we all read the same code, why we chose to do the arrest or not do the arrest. And the better you are at that, usually the better cop you are. But everyone makes mistakes or reads something wrong. Officer Pratt stated he had determined that one of the elements for assault was missing. Officer Pratt explained this as being the attempt to use unlawful force or violence to cause bodily injury to Brian. Officer Pratt described this stating, implicit with attempt is intent. You can't attempt something with no intent to do it. So obviously intent is part of assault. Officer Pratt stated this was the reason why he asked Gabby what her intent was when she was hitting Brian. Officer Pratt stated most guys our size would say that you can't slap people and do that, but followed that up with, well, we've never been a 110-pound female. Officer Pratt stated Gabby's intent was important, and when she was asked why she was slapping Brian, Gabby said, I just wanted him to stop telling me to calm down. Officer Pratt said that sounded very reasonable to him and that he didn't think she had the intent behind it to do bodily injury to him. I think she wanted to modify his behavior, and she doesn't have the tools in her toolbox to do it. Officer Pratt added, that's why we spend so much time in court, way more time than I have on the side of the road. They have entire days of trials spent nothing more than just establishing intent on a crime. I don't have special expert witnesses on the side of the road. I don't have 5 days of my trial with these people to figure out who to charge. I got like less than an hour, apparently. So they trust me after 16 years to figure it out. And I took my 16 years of experience and said, I believed Gabby based on the totality of the circumstances and based on what she appears physically capable of and based on what I saw him doing and act the way he was acting, that I don't think she assaulted him. Officer Pratt also added what he believed could happen if Gabby had been arrested and Brian bailed her out and signed the protective order waiver. Officer Pratt pointed out that Brian had said they didn't have a lot of money. Officer Pratt said, so if he's going to go bail her out, is he not going to have more control over her now? Now we're out of money. blame it on her because I had to bail you out. All it's going to do is put the power and dynamics more on him in his favor, where he's like, now we have to come back to court or video court. Now we don't have the money because I had to bail you out. Oh, we're in another fight. Go ahead and call the cops. How did that go for you last time? I asked Officer Pratt where he looked up the code for assault, which he stated it was from the Utah legislature website. I asked Officer Pratt if at the time of this incident, if he believed he read the entire definition of assault to Officer Robbins. Officer Pratt stated he believes he did, and also stated he looked up the definition of bodily injury to further expand on what the code was stating. Officer Pratt stated he first had to see if the crime of assault was met, and if so, then they would be able to attach the domestic violence attribute to that. However, if there was no crime of assault, then it couldn't be a domestic violence assault. I asked Officer Pratt if he still believes to this day, November 1st, 2021, that attempt and intent were synonymous or implicit with each other. Officer Pratt stated, to this day, I still believe that. Officer Pratt stated, if he is wrong, he would adjust his future interactions in acknowledgement of that information. I explained to Officer Pratt the four culpabilities and their levels. I also read Officer Pratt the assault code in full. Officer Pratt said, that does change things. Officer Pratt stated he is sure he has read that part of the assault code before and it has to be addressed. Officer Pratt said he probably got sidetracked with the bodily injury portion of the assault code and went and read the definition for bodily injury, neglecting to scroll down and read the rest of the assault statute. Officer Pratt said, and if I did, that's a mistake, and it may have changed our decisions, but I can't say that even here now until I read it and really think about it for a few minutes, because I do take the act of putting people in handcuffs and taking their freedom and giving them charges very seriously. And I usually spend a little bit of time reading up on it first and then trying to figure out if that's going to fly. So, yes, that second part you said I would admit that could have changed what we decided to do, but I would still have to look it over and think about it. Applicable interview responses. Officer Robbins, in a subsequent interview with Officer Robbins, I asked how he reached the conclusion that an assault did not take place. Officer Robbins stated he observed the code Officer Pratt showed him, and in that code it said, with the intent to cause harm. Officer Robbins stated, I went with that one because she said that she didn't have the intent to harm him. I asked Officer Robbins if he just went with what he was told by Officer Pratt or if he actually observed the code himself. Officer Robbins stated, Officer Pratt showed me the code. Officer Robbins added again that the assault code says, with the intent to cause bodily injury. I read the assault code in full and asked Officer Robbins if anywhere in the code it said the word intent. Officer Robbins said it might have been somewhere else, I'm not sure. I asked Officer Robbins if he actually felt at the time of this incident that the definition of assault included the intent to cause bodily injury. Officer Robbins said yes. I asked Officer Robbins if his decision during this incident was a decision made to benefit himself or anyone else. Officer Robbins stated he did what he thought was best for the situation. I asked Officer Robbins if he was aware of the duties of arrest in Utah State Code. Officer Robbins stated he was aware. I read him the duties of arrest and asked Officer Robbins if he believed he followed Utah State Code. Officer Robbins said, at the time I did, I asked Officer Robbins how he reached the conclusion written in his report that states, I do not believe the situation escalated to the level of a domestic assault as much as that of a mental health crisis, and I asked how he quantified the two. Officer Robbins stated he was trying to fix the problem and figure out what the underlying problem was. Officer Robbins didn't feel it was an ongoing issue of assault, but an ongoing mental health issue, which caused the domestic. I asked if this incident was more of a mental health crisis, why he didn't get Brian and Gabby in touch with mental health professionals. Officer Robbins stated it was a busy day and calls were stacking up left and right and mistakes were made. It completely slipped my mind. I didn't even think about it. Officer Robbins stated the stress of the situation and everything else going on at the time contributed to not thinking about doing this. 2. BI. If the peace officer has probable cause to believe that there will be continued violence against the alleged victim, or if there is evidence that the perpetrator has either recently caused serious bodily injury or used a dangerous weapon in the domestic violence offense, the officer shall arrest and take the alleged perpetrator into custody and may not utilize the option of issuing a citation under this section unfounded. Based on all the information provided, I do not find that this section applies in this case. There was no information provided that would cause any of the officers to believe there would be continued violence. There was also no information provided that there was serious bodily injury or that a dangerous weapon was used in the domestic violence offense. If a peace officer does not immediately exercise arrest powers or initiate criminal proceedings by citation or otherwise, the officer shall notify the victim of the right to initiate a criminal proceeding and of the importance of preserving evidence in accordance with the requirements of Section 7736(2). One sustained due to Officer Robbins not exercising arrest powers by custodial or citation arrest. This section would apply to this case. Brian was adamant he did not want to pursue charges against Gabby in this case and made it clear through his statements that he wouldn't want to initiate criminal proceedings in the future. Brian said, "I'm not going to pursue anything," further stating, "I want a checklist of things to do to get rid of it." There are numerous things the officers did do as it applied to this section. The officers took action that provided safety for Brian by separating him from Gabby. The officers provided emergency shelter to Brian, and they asked if he needed medical treatment. In response, Brian said, "No, I'm okay," and referred to his injuries as baby injuries. What I have found that the officers did not do was meet the requirements in accordance with UCA 7736 2.1. This requires Brian be provided with the immediate and adequate notice of the rights of victims and of the remedies and services available to victims of domestic violence. This should be a written notice that provides information on how to obtain a protective order, list of shelters, services, and resources, along with phone numbers to assist the victim in accessing any needed assistance. 3. If a law enforcement officer receives complaints of domestic violence from two or more opposing persons, the officer shall evaluate each complaint separately to identify the predominant physical aggressor. If the officer determines that one person was the predominant physical aggressor, the officer need not arrest the other person alleged to have committed domestic violence. In determining who the predominant aggressor was, the officer shall consider 1. Any prior complaints of domestic violence, 2. The relative severity of injuries inflicted on each person, 3. The likelihood of future injury to each of the parties, and 4. Whether one of the parties acted in self-defense. Unfounding. Based on all the information provided, I do not find that this section applies in this case. There was no information provided that would cause any of the officers to believe there would be continued violence. There was also no information provided that there was serious bodily injury or that a dangerous weapon was used in the domestic violence offense.